Imagine opening your laptop to check the joint bank account, only to find the balance draining in real time. Your spouse is quietly preparing a massive offshore wire transfer, effectively erasing your shared life savings before the divorce papers are even drafted. The standard legal reflex, filing a lawsuit, is practically useless here. Normal family court procedure requires serving the opposing spouse with legal documents and then waiting weeks for them to respond before a judge ever hears the case. Serving those papers acts as a giant warning siren. It gives a malicious partner the exact window of time they need to hit send and instantly move the funds out of the country. We are talking about movable assets, cash, stocks, and crypto. Once these assets cross international borders, recovering them becomes a logistical nightmare involving foreign jurisdictions and staggering legal fees. Stopping this financial bleed requires catching them completely off guard. You have to secure an emergency court order to freeze the assets before your spouse even realizes they are being sued. You cannot just walk into any courtroom to stop this. The Provincial Court of British Columbia, which handles many everyday family matters, has zero legal authority to deal with the division of property or issue restraining orders over financial accounts. You have to go straight to the Supreme Court of British Columbia. This court possesses inherent, unlimited jurisdiction, making it the only venue in the province with the sheer legal muscle to intervene in property disputes of this scale. Getting a filing stamped at the Supreme Court Registry is just the entry fee. The actual hurdle is convincing a judge to wield that immense power in absolute secrecy. The primary weapon for this maneuver is Section 91 of the Family Law Act, which allows a judge to restrain a spouse from disposing of property. Because of the flight risk, you must apply for this order ex parte, meaning without giving your spouse any notice. This goes against the most basic principles of the justice system, which usually guarantee the accused the right to defend themselves. Because the judge only hears your side of the story, the law places a crushing burden on your shoulders. You are legally required to practice absolute transparency. You have to make full and complete disclosure of all relevant facts, even the ones that severely hurt your own case. If the court later discovers you hid inconvenient truths to get the order signed, the backlash is severe. The judge can immediately cancel the freeze, force you to pay special court costs, and award damages to your spouse for the inconvenience. To legally strip someone of their financial autonomy behind their back, you have to weaponize your own radical honesty. Even with the order in hand, a massive geographical hurdle remains. A British Columbia court order cannot simply command a bank in Switzerland or a brokerage in the Cayman Islands to lock an account. The court generally lacks in rem jurisdiction over assets located in other countries, meaning it has no direct legal authority over foreign real estate or international corporate vaults. The law has a workaround, in personam jurisdiction. The Supreme Court cannot reach the foreign bank, but it has absolute authority over the BC resident. The judge orders the resident directly. They are legally forbidden from touching their global assets, no matter where they are. In personam jurisdiction neatly bypasses the complexities of international borders by reducing the entire problem to a matter of strict personal compliance. There are rare, highly complex cases of wealth flight where even a standard Section 91 order might not provide enough security. For those situations, lawyers pull out the nuclear option, the marital injunction. This is an extraordinarily aggressive legal tool. To get it, you must pass a punishing three-part test. Prove a strong legal entitlement to the assets, prove a real risk that they will be disposed of, and financially guarantee to cover any wrongful harm caused if it's a mistake. The marital injunction is the absolute limit of the Supreme Court's preemptive power, reserved strictly for the most extreme, calculated threats of financial evasion. Once the judge signs the order in that closed-door hearing, the execution is instantaneous. The legal documents are rapidly and simultaneously served to your spouse and all relevant financial institutions. The physical reality of the ambush hits almost immediately. The offending spouse might walk up to an ATM for a routine withdrawal or log into a portal to initiate that offshore wire, only to discover all access has been completely revoked. The wealth is trapped. And it is trapped entirely because the maneuver was executed with absolute secrecy and overwhelming speed. The bleeding of assets stops exactly where it is. The money is preserved in a secure, frozen state, completely out of reach. This forced financial pause levels the playing field. It ensures that the actual division of your shared property can be negotiated or litigated fairly, entirely removing the looming threat of vanishing money from the equation. British Columbia family law provides incredibly heavy shields for family wealth. You just have to know exactly which court to walk into, strike with total surprise, and approach the bench with absolute transparency.